Get the screen. This it. Got it.
Yeah.
Yeah. Jefferson County Court at Law number 2 is now in session. My name is Judge Terrence L. Holmes. First of all, I'd like to welcome all of you here to court this morning. You have been asked to come here to court because you have a case that is on our arraignment docket. Now, the case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type cases. For example, in a felony case, it could be a capital murder, it could be a first-degree felony, a second-degree felony, third-degree felony, or a state jail felony. If a person is convicted for a capital murder, range of punishment is anywhere from life to death. If a person is convicted of a first-degree felony, range of punishment is 5 to 99 years to life, fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is 2 to 20 years in the state penitentiary, fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, and a fine up to $10,000. Or if you're convicted of a state jail felony, the range of punishment is 6 months to 2 years in the state jail, and a fine up to $10,000. Now, the case that you have in this court, as I said earlier, is a misdemeanor case. The difference between the misdemeanors and the felony cases, or your felony cases are normally referred to as your most serious type cases, and your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as the felony offense. Now, the categories of misdemeanors is Class A, Class B, or Class C. Class A misdemeanor is our highest range of misdemeanor, and the Class C is the lowest range. Now, for a Class C misdemeanor, the range of punishment is fine only. You cannot be given any jail time. You only can be given a fine. For a Class B misdemeanor, the range of punishment is 0 days to 6 months or 180 days in the county jail, fine up to $2,000. For a Class A misdemeanor, which is the highest misdemeanor, the range of punishment, if you're convicted, is from 0 days to 365 days in the county jail, which is a year, or a fine or a fine up to $4,000. As a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, the paperwork that has been handed out, that was on the chair that you're sitting in, it's on a clipboard. Do you see her looking around? You don't have one? No, okay. That paperwork is titled Judge's Explanation of Rights of Defendants Without an Attorney. Now, as a defendant in a criminal case, you have 3 options with regards to an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, that first document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place the name of the attorney on the line to the right and your initials on the line to the left. If you want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed an attorney, then you put his name on the line to the right, on the fourth line to the right, and your initials on the line to the left. If you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that says defendant, and you will place today's date on the line that says date. And that date, today's date is March 8th of 2022. If you are waiving your right to an attorney and desiring to represent yourself, then you would have to read and sign the second page. The second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 8th day of March of 2022 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that says defendant, and you will place today's date on the next line that says date, and today's date is March 8th of 2022. Now, you have other rights as a defendant in a criminal case as well. Another right that you have is a right to have a trial by jury. Where those individuals are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they'll decide whether or not you're guilty or innocent after listening to all of the evidence. You have a right to waive or give up your right to have a trial by jury as well. And what I mean by waiving your right to have a trial by jury, you'll be giving up your right to have a trial by jury. That is, you will not be having a trial by jury. You'll have a right not to have a trial by jury. And by doing so, your case will come before this court or before the judge in one of 3 ways. One way it could come before the judge is by way of a trial. We call that trial a bench trial. And what a bench trial is, it's a trial with the judge only. And the judge will be the judge in the case, as well as he'll be the fact finder. In essence, he'll be listening to the case, such as what a jury would do, but he'll be the judge and the jury. And at the end of the case, the judge will decide whether or not you're guilty or innocent And if you're found guilty, the judge would also assess the punishment. Now, your case can come before the judge also by way of a plea. There are two types of pleas. There's an agreed plea bargain and there's an unagreed plea bargain. Now, an agreed plea bargain is an agreement that you have reached with the district attorney's office. In essence, you will talk to the district attorney's office, or your attorney will talk to the district attorney's office, and the district attorney may make an offer to settle the case. And if you accept that offer, we call that a plea bargain agreement. Now, if you have reached a plea bargain agreement with the state or the district attorney's office, then the case will come before the court. And once the case comes before the court, the judge does not have to follow the plea bargain agreement. However, if the judge does not follow that plea bargain agreement, you have a right to withdraw, which means to take back your plea. For example, let's say you and the state has reached a plea bargain agreement for, say, 5 days in jail. And then it comes before the judge and the judge says, well, I'm not going to follow that plea. Then at that point, you have a right to withdraw to take back your plea. Or you could tell the judge, well, I'll take my plea back. I don't want to plead because he's not accepting the plea bargain agreement. That's what we mean when we say you have a right to withdraw your plea. Now, you also have a right, the other way you come before the court is by way of an unagreed plea bargain. An unagreed plea bargain simply means that you and the state have not been able to reach an agreement to settle your case. And so therefore you want the judge to determine what the punishment will be. That's called an unagreed plea. That's an unagreed plea bargain agreement, okay? So those are the ways that your case will come before the court. Now, the other right that you have a right to have witnesses to come to court. And what witnesses do, witnesses can testify. They'll testify either for you or against you. If you're representing yourself, you can ask them questions. Or if you have an attorney, your attorney can ask them questions. And we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And what that means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses. It only means that you will not be calling witnesses. And so you have a right to waive or give up your right to have witnesses in your case. Now, you also have a right against self-incrimination. And what that basically means is you have a Fifth Amendment right of the United States Constitution against self-incrimination, which means that you have a right not to testify in your case. And the state, no one can force you to testify in your case. Now, you also have a right to waive or give up that right against self-incrimination. And that simply means that by waiving your right, you'll be deciding to testify in your case. You also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. You have a right to see the documents. You have a right to see witness statements, police reports, photographs, videotapes, and DVDs, whatever they have. You have a right to have access to that information. That's called discovery. And you also have a right to waive or give up your right to have discovery, which means you have a right to say that you do not want to have access to the evidence that the state has against you. Now, you have a right to enter a plea. There's 3 types of pleas that you can enter. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges against you. Now, everyone that's here in court for arraignment, you are out on bond. Either you're out on a PR bond, a cash bond, or a surety bond. So you went to jail and then you bonded out. Now, every day that you spent in jail, that can be used as credit toward your sentence. For example, let's say you and the state has reached let's say you've been in jail 5 days and then you bonded out. And you and the state has reached a plea bargain agreement And the plea bargaining agreement is for you to serve 5 days in jail. What that means is you will not have to serve any more time in jail because the time that you spent in jail will be credited toward your punishment. So you'll be given credit for time served. Now, if you offering you 7 days in jail, you spend 5, that means that you would have to do 2 days in jail on that sentence. The other thing is, if you and the state has reached a plea bargaining agreement and the agreement is for a fine only. Now, every day that you spent in jail is credited as $100 per day that will go toward your fine and court costs. So for example, you and the state have reached a plea bargaining agreement for you to pay fine and court costs of $500, then, and you already spent 5 days in jail, you will not have to spend any more, you won't have to pay anything because the 5 days you spent in jail is equivalent to $500 that will be credited toward your fine and court costs. Now, if they are offering fine and court costs of $700, you spent 5 days in jail, that just simply means you'll have to pay $200. Now, if you don't have the $200 to pay on that day, then the court can have you to pay off the $200 in what we call an installments. In essence, they can put you on what is called a pay plan to pay it off over a period of time. Now, let's say, even if that's done, you are, say you're indigent and you do not have the money to pay it, then the court can convert your fine and court costs to community service. And the way community service work is every hour that you work in community service, $12.50 will go toward your fine and court costs. So if you work 8 hours in one day, that's $100 that will go toward your fine and your court costs. Now, Jefferson County has a program that is called pretrial diversion. And what pretrial diversion is, they put you into a program is ran by the probation department, but you're not on probation. And once you get into the program, they will dismiss your case and you complete the program, you can get it expunged from your record. And what I mean when I say expunged meaning it can be wiped off, deleted, or erased from your criminal record. Now, the way it works, it cannot be an offense for resisting arrest or unlawfully carrying a weapon. For any other offenses, the district attorney's office has a program called pretrial diversion. And the other thing is, not only it cannot be an offense for resisting arrest or unlawful carrying a weapon, but you cannot have a criminal history. It has to be your first time, your first offense. And then the third requirement is you would have to get an attorney to assist you to get into the pretrial diversion program, okay? Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court, and it's for veterans only of any one of the branches. And the only thing you have to do to get in that program basically is to be a veteran. And if they get into the program, the case is dismissed and you can get it expunged from your record upon completing the program. And we have forms here that if you're interested, you can make the application to the district attorney's office. Now, this court has a program also that is called the Community Safety Initiative. We call it the CSI program. That's a program that started within the first 100 days of taking office in March of 2017. And that program is designed to make Jefferson County a safer place. And the way we make Jefferson County a safer place is by addressing the issue of what we call recidivism. Recidivism simply means people committing crimes over and over, recommitting crimes. And the way the program works is We have a partnership with some agencies in our local community. Now, we have a partnership with Spindletop Center. Spindletop Center is our local mental health agency. And Spindletop, and in fact, we have individuals here in the jury box who's from Spindletop. But Spindletop, they can do private interviews, they can do an assessment, and they can draft the treatment plan either for outpatient or inpatient services. Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery Program. And that program is a drug and alcohol intervention or counseling program. And the program that Spindletop has is, I think, for ATAR is 21 years and younger. If you're 21 or older, then we have a partnership with OZAR. OZAR is, it stands for Outreach, Screening, and Assessment Referral. It's a local mental health, it's a local alcohol and drug abuse council. And that program, both programs, you'll be able to get a screening. They can develop, they'll do an interview. They also can develop a treatment plan, either outpatient or inpatient treatment to address your drug or alcohol needs. Now, for individuals who are not working or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. And that program is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas that you choose, they will assist you at getting employment in the area that you're trained in. If you have not finished high school, CICE also has a GED program where they can assist you to get your diploma. Now, all of these programs that I've just mentioned to you are free. It does not cost you anything. Only thing you have to do is just have a desire to be in one of the programs. And as I said earlier, we have individuals here from Spindletop, and they'll come. Deputy Hinton is going to come and he'll talk to you a little later about the program that Spindletop has. Now, these programs that we offer, as I said earlier, is designed to make Jefferson County a safer place. It's designed for all of us to live, work, go to school, raise our children, and to go to church. And the program, I tell people this all the time. When you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that comes before the court. And we're trying to make a difference in our community in Jefferson County. And in county court at law number 2, we do not just give time, we take our time. And the reason why we take our time is because we believe that it's better to it's better to address the problem than just arrest the problem. And so if you're interested in any one of these programs that we just mentioned, or we just spoke of a little earlier, just let us know, and then we'll assist you at or direct you into the people that you may need to talk to so that you can get into these programs. Now, the other thing is this here. I mentioned to you earlier that if you have a fine and court costs and you could not pay the fine and court costs, then we can convert it to community service. And by law, all of these programs that I've just mentioned can be used as community service. So for example, if you are indigent, you cannot pay your fine and court costs, the court can convert it to community service. And if you're in one of the programs, that program could go toward your community service and your fine and court costs at the same time. So I tell people this all the time again, you can kill 3 birds with 1 stone. And what I mean by that is this here. If you're ordered to pay a fine and court costs, that's one thing. And if you cannot pay it, we convert it to community service. That's the second thing. And if you're in the program, while you're in the program, for example, let's say you're in a GED program. So while you're in GED class, every hour that you're in GED class, which is the third program, the third thing, 1 hour is going toward community service, and $12.50 is going toward your fine and court costs. Okay? Or if you're in the drug or alcohol program, or if you're in the job training program, it's the same thing. So you're doing one thing, but you're getting credit for 3 things. You're getting credit for being in the program, you're getting credit for community service, and you're getting credit for paying your fine and court costs. Okay? So as I said earlier, if you're interested, just please let us know. And at this time, we're going to ask Deputy Hinton, who is our mental health officer, to come and tell you about the program that Spindletop has.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my 2 partners, Sarah and Brandon. I think these 2 are qualified mental health professionals with Spindletop. The reason we're here is because the judge has graciously allowed us in his courtroom because he cares about every single person that comes before his bench. And what the judge has found is people who have legal issues that come before his bench commonly, more so than not, have either mental health issues or have substance use disorders. The judge believes that if he can help you with those underlying issues, he can get you out of the cycle of arrest. Now, maybe this is your first time, maybe this is your 10th time. Either way, there's still hope. We can provide resources, options, opportunities for you. We have a great wealth of resources where we can direct you, advocate for you, and help you. At the very least today, I want to get this in your hands. It's a brochure about what we do, and a little bit about the court program. It's also the 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, maybe this doesn't apply to you. Maybe it applies to a family member. If it does, we still like to get this in your hands so you can bring this to your family member, and we will be able to help them as well if you will give us that opportunity. Now, everything boils down to choices. Today, you're going to have a choice. It's going to be up to you whether you want to share your needs with us today, but we're here for you. We'll be visiting with you as the court goes into recess, and you'll have an opportunity to visit with us one-on-one, privately. If that is uncomfortable for you, we can take your number. We can call you later when it's more convenient for you. Whatever it takes, we're here to advocate for you, and that's our goal. That's our objective, is to help you and give you the quality of life that you want for yourself and your family. Does anyone have any questions? Thank you very much. You're very kind for listening. Thank you, Your Honor.
You're welcome. Okay, ladies and gentlemen, the paperwork that has been handed out, make sure that you fill out the paperwork if you haven't already. If you need some assistance, we have someone with our court personnel who will be happy to assist you. Now, we're going to have someone from our court personnel who's going to come by and pick up the paperwork from you, and then we have to go through that paperwork. And so this is going to take a little time. So at this time, we'll be in recess to give our court personnel an opportunity to pick up the paperwork from you.